Hey guys, good morning. What's up, everybody? My name is Debbie. Welcome to my channel. We are on part 10 of the Waukesha Christmas Parade Massacre, Wisconsin v. Darrell Brooks. It's our part 10. It is also day 10 of the trial. Good morning, Judy. Good morning, Marty. Let's see what trivia Judy has for us today. 3 weeks prior to the parade, Brooks punched Erica before running her over with his vehicle. His charges were second-degree recklessly endangering safety with DV, a felony, as well as disorderly conduct. Brooks posted $1,000 bail on November 19th, 2 days before the parade, and was released the same day. He was not convicted of these charges until September 2024 and sentenced to an additional 9 years in prison. Wow, that was effective, wasn't it? Jeez. What is wrong with our judicial system? I mean, according to lawyers, we have the best judicial system in the world. I'm not saying we don't. I'm just saying we need some reforms because that's ridiculous. If he had stayed in jail, this would have never happened. Why did. See, and here's the thing I don't understand. Why did they prosecute him for the parade first? And then they didn't get to Erica's charges until 2024. It seems like they should take them in order. That's just weird to me. Like, I know the victims wanted, I guess that's why, because the victims, the way Sue Opper talked was that the victims wanted it over and done with before the anniversary date came around. So maybe that's why. Because, I mean, that's the way it seemed, the way Sue Opper was talking when it came down to scheduling sentencing and victim impact statements and all that at the end. They wanted to get that done before the anniversary because I think Sue Opper said people were leaving town. Judy, when did they have the Christmas parade? Because didn't you say the anniversary, like the next year they had a Christmas parade that they live streamed for everybody to watch? Was that the next year? Oh, that's right. It was in two different places. Milwaukee put the trial on hold due to him being in Waukesha. They waited until his trial was over until they resumed the Milwaukee trial. Hey, Jill. Okay, that's why. I don't know. It just still seems weird to me. I guess I get it, though. I still say they should have never let any violence against another person. I don't know. I've never been in jail. The parade, the next year was the first week of December. Because I remember Sue Opper saying something about people going out of town because they didn't want to be there that week. It was a reminder of what happened or something like that. What I was going to say was anybody that has like a violent crime against someone else should not get bond. But then, like I said, I've never been in jail. And you got to make the punishment fit the crime. So if it's just like a DV thing, but he ran over her foot with a car. I mean, that's extreme DV. Like, you don't normally do that. When you're having a fight with your partner, you don't run them over with a car. Not usually. I don't know. I'm just trying to figure out a way they could have prevented this from happening. I mean, they had the guy locked up and then they let him go 2 days before this happened. It's just bizarre to me that this could not have been prevented with the history that this jackass had. Oh, and by the way, we're starting a new trial today. So we're going to do this for about an hour and a half. And then we have a brand new trial. Yay. And if it's ends up being boring, like the last new trial we started, then I guess we'll just go back to Brooks. But I wanted to get back into our regular schedule of trials of the past in the morning and then Wiggles. Oh, they are a pain for prep. Colonoscopy. Yeah. The actual, when is it? Tomorrow? What was that? That was bizarre. I've gotten that came out of nowhere. I've got nothing else running. That was weird. My computer's haunted. Yeah, the prep is the worst part of a colonoscopy. After, like the actual thing, is the best nap you will ever have. I don't mind getting them because the nap is great. It's the best, I'm telling you. The best sleep ever. It's sleep 90,000 words. The sleep, though. The sleep. The sleep is amazing. It's like, it makes you wonder, why can't I have this stuff at home so I can sleep better at night? It is amazing. 10:40. Oh, you're not going to be with us all day. Hey, sweetie. How are you? The bail was the issue. The new and reformed bail system in Milwaukee County. Oh. You'll hear a victim speak on it during impact statements. Oh, good. Okay, I thought my dogs were inside, yet I hear a dog barking outside. I will let Travis deal with that. Let's get started. Oh, I put some pictures from my trip in the community section. Hey, Jennifer. I wrecked the Lincoln twice today. Chipmunk is really mad at me.
Agree to that, Your Honor, or consent to that.
You're too Darrell. I did a picture with the stormtrooper, and he was like, "No." Oh, we had so much fun. I didn't make Travis sit through any shows because he doesn't like shows. He just wants to ride rides. And He wouldn't do Tower of Terror with me because he doesn't like drop towers. So that's the only ride we didn't ride. So we rode all the rides except one, and did no shows. So we had a good day. Come on, computer.
A suit and tie and a mask.
I don't consent to being called that name, Your Honor,
I understand.
for the record.
And
I think his dad
have advised you previously that I will continue to refer to you at times by that name, as I believe it's appropriate given the charging instruments in this case, and other evidence now that's been received during the course of this trial where I believe we are using the accurate name. With that, I
don't agree to that, Your Honor, or consent to that.
Your lack of consent is noted. So before we go forward, I have a couple of things on the record. I know Mr. Brooks has filed something, but before I get that, I told the parties on Monday I had excused one of the jurors for
being stupid today, you guys. Jennifer, that was the first time I had ridden Rock and Roller Coaster since I lost 70 pounds. I thought that the restraints would like come down farther. They didn't. I floated in my seat for the first time on that ride. It was so cool. It was so cool. Did I put the Rock and Roller Coaster picture in the community tab, y'all? I think I did. Did you see it, Jennifer? My face. And my husband just sitting there. Like he's just sitting in a chair at home. And my face. It's like Thank you, Hillary. It was fun. It was so much fun. It made it a completely different ride because I was like, oh crap, where am I going? What's happening? But yeah, it was cool. It was so much fun because before I didn't really I knew I was upside down, but it didn't feel any different because I didn't move. I was like, am I upside down right now? But this time, I knew I was upside down because I was I was moving up and down, and I didn't do that last time. Oh, it did. It did. It was so cool. I loved it. This is crazy, Judy. Crazy. I remember when it was new, and I said something to you guys, and you couldn't find it. But yeah. That's nuts. Nuts. Okay.
A health reason. And it has come to my attention that I now have a second juror with the same health concern. Out of an abundance of caution, I'm going to bring the jurors out to question them about their whether any of them have any concern about continuing to serve on this jury, given the health concern. I am referring to a COVID concern. I'm not going to ask any particular juror whether they've tested positive or not, or whether they've had an exposure. But I am going to ask them questions about their willingness to continue serving, whether it's interfering at all with their ability to pay attention. Out of an abundance of caution, we have brought in 2 air purifiers, although I am told that because of the new building and the HVAC that's in this building, and I received this from our facilities mayor, has a UV light system that disinfects the air at a higher air exchange rate than the purifiers, and that the system was specifically designed designed so that no special standalone systems are needed. But again, out of an abundance of caution, we've had 2 air purifiers put in this courtroom. I'm putting a third one in the jury room. We have also provided jurors, should they wish, with masks. We've increased the hand sanitizers and the disinfecting wipes. We've always had the hand sanitizer. The moment been in, I like to put on the record, I did advise the jurors on Monday that one of the jurors was not going to be with us any longer due to a health concern. I asked them at that point if anyone had any concern. I did indicate at that point it was a possible exposure, and they all indicated no, they didn't have any concerns. But again, out of an abundance of caution, I feel it's important to now question them while they're in the jury box to ensure that there aren't any issues related to that. So with that, I am going to instruct the jurors to be brought out for that purpose. And then they'll be excused after that so we can continue the discussion regarding that, and then deal with, if need be, the other tension today.
Your Honor, will we be addressing subject matter jurisdiction?
Oh, there he goes.
No, not at this time.
Still has yet to be proven for the record. I don't know if the audio is on, but.
Oh, now it is.
All right for the jury.
Could you have a microphone available, please, if need be? They're behind you. I don't know if you can see it. Oh, wait, if you could bring me that. Michael, I'm going to hand you this. We're not going to take testimony at the moment. This is preliminary issue. Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, I brought you out here not taking testimony at the moment. I have made a record previously regarding COVID-related concerns with the jurors. I know it's concern. I also put on the record that on Monday, when I advised the jurors of that, I asked you all if anyone had a concern regarding that, and that no one indicated they had a concern. I have been made aware of a second issue and potential exposure, and so I wanted to make a record in open court and to ask each one of you if any of you have any concerns about continuing your service in this case due to exposure to COVID. And so I'm just going to go through each one. Hopefully I can see all of your numbers from here. I'll just start from the back row and move from my left to right, front row, my left to right. And I also want to let you all know we have a very, very good HVAC system. I made a record of this while you were not here. But this is a new building. It has brand new technology. I've been told that the HVAC system in the courts tower, and this was told to me by our facilities manager, has a UV light system that disinfects the air at a higher air exchange rate than purifiers, but out of an abundance of caution, I've had 2 air purifiers also put in this courtroom, and I've had one put in the jury room. I believe you would be able to confirm for us as well that when you got into the jury room this morning, there were extra sanitation supplies along with masks. And so with that, I am just going to identify you by number. First of all, juror number 11. Do you have any concerns about continuing your service in this case, specifically? All right, thank you. Let me actually go back to, would the fact that you may have been exposed in any way interfere with your ability to pay attention and ultimately render a verdict in this case?
No.
All right, thank you. And then, let's see, I know our bar's really, juror number 48, if you could also answer those two questions.
No concerns, both ways.
All right, thank you. And then juror number 46.
No concerns.
Thank you. Juror number 34.
No to both.
Thank you. Juror number 27.
No also to both.
Thank you. Juror number 30.
No concerns to both.
Thank you. Juror number 1.
No concerns to both.
Thank you. And then what's your number?
6.
6. Juror number 6.
No concerns to both.
Thank you. And then juror number 14. I'll just start there.
No concerns to both.
Thank you. Juror number 10.
No concerns to both.
Thank you. Juror number 51.
No concerns to both.
Thank you. Juror number 45.
No concerns to both.
Thank you. Juror number 19.
No concerns to both.
Thank you. Juror number 41.
No concerns to both.
Thank you. And juror number 3.
No concerns to both.
All right. Is there anything I haven't asked of the jurors or any other concerns related to that that you would want to bring to my attention? If so, just raise your hand. There are no hands raised. I can also tell you from our initial days of COVID, when we started up jury trials, we do have plexiglass panels that I could put in between anyone who would want one. Is there anyone here who would want that? If so, raise your hand. No hands are raised. That's really all I have. I don't know if there's anything either of the parties would want me to ask the jurors from the state on this topic. All right, Mr. Brooks?
No.
All right, thank you. I'm going to excuse the jurors then, and then when we're ready, we'll have you brought back out. And thank you so much. Thank you. Be seated.
Judge, can I ask you a question?
Go ahead.
We counted 15 jurors in the courtroom.
I excuse one.
You excused one earlier in the week too, though.
No. I'm only talking about the one. The other one I didn't excuse.
I see.
And,
Okay.
and thank you. I'll make a record of that. I did not excuse given when that person reported their symptoms and where we're at. So
that person is here
yes.
and willing to continue serving?
Yes.
Okay, thank you.
And I will make further record that none of the jurors are wearing masks. I'm not going to mandate. I believe it's a personal choice. And that would also be consistent with, I believe, our county policies as well. So unless there are anything related to that, I have a couple of other issues I need to address this morning.
I got something for that.
Go ahead.
The person that's, or the two people rather, that are having the COVID concerns. I know you said you wasn't going to ask them had they test positive or the results of any testing. Do you know if there has been exposure on their end to COVID exactly, or is that just a caution thing?
My understanding is that I've had 2 jurors test positive throughout the course of this trial. And I'd make a further record that they're the only ones within 6 feet of each other, right? They, and perhaps our civilian bailiffs, they've not been in, obviously, contact with anyone in the gallery. I don't know if maybe Attorney Opper might be within 6 feet. I don't think so, but I haven't measured it. Obviously, you're not within 6 feet of any of them, but that's a good question to ask, and I'm glad you asked that, and I wanted to make a record of that as well.
Yeah, that would be my question to it.
And you've asked it. And shut up.
I guess in reference to me myself just having the same concern a few weeks ago. So that would be the reason why I would want to know exactly any details that could be provided.
I'm providing all the details that I will. Again, for the record, you have not been exposed, from my opinion, because of the distance that you are away from them, and my understanding based upon my review of county policy.
Yeah, I'm not saying me myself have been
Understood.
exposed.
Well, that's why I asked them though too, right? I wanted to make sure they had no concerns, or if they had a concern, to see if I could accommodate it in any way. I'm satisfied that if they don't have a concern, that we can continue forward.
Have they ever, the entirety of the jury though, have they been exposed in any way?
I don't know the specifics because of the 6-foot, right, rule, and no one has asked me to investigate that further.
Wouldn't it be smart though to see?
I don't believe that's necessary under the circumstances.
Well, if anything, just for future reference, like, what if it plays a part later on?
Well, I'll certainly take your concerns under advisement, and if I believe any
Later
further
on.
questioning needs to be done, I'll do that. At this point, I don't believe it needs to be done, but I'll think about that and I'll take it under advisement, and if I change my mind, I'll let you know.
Yeah, I'm just saying, because if anything, it probably would be smart for the long run to make sure no one else was compromised, considering that.
Let me make
Yeah.
a record there. No one has indicated they are compromised. I don't think we can make assumptions about how anyone who's been exposed or tested is feeling. You can and test positive. You can have mild symptoms. I trust my jurors that they would report if they're not able to sit through the proceedings. And I will further advise them through the bailiffs that they are to report if they ever get to a point where they feel they're not able to sit through here, and if so that we're advised and I can tell the parties.
Yeah, that's what I was referring to, because it went from Monday, which at that time it wasn't known. Could have been flu, could have been just not feeling well, could have been anything, and then today is, then you kind of worry about tomorrow, Friday, over the weekend.
Mr. Brooks, I share all of those concerns, but my other concern is that we are in the 3rd week of trial, and that we should keep going until the conclusion of this matter.
All right, I just wanted to put that on the record, because
I appreciate that.
it seemed like the circumstances was
Stupid.
Are you making any specific requests given this information?
well, I believe that
We don't care what
the
you
jury clearly all congregate together. I think to make sure everybody is tested. I mean, that's it would be smart to do that.
I'm not going to mandate this today.
And the grounds for the denial?
Because she said so.
I'm not going to mandate that the jurors be subjected to testing. They're the ones who indicated they are comfortable
Because this is
being
America,
here. They don't have
Darrell.
concerns.
We don't
And again, I would
make
trust them.
people do
It
stuff.
would still refer back to Monday, when the first knowledge of someone having an illness or a potential illness was those same questions that were asked today, asked Monday. And
I did
I'm
not.
quite sure.
I certainly questioned them much more. It was a very brief. I put what I said to them on the record earlier. It was certainly not what we expected.
Hey, nobody cares. Nobody cares.
We did here today, and the record reflects that.
Right. I'm quite sure, though, that all the jurors Monday said they didn't have any concerns as well. And then now today, someone else, same thing being said. So
I understand what
if
you're
it
saying.
happens again, Same thing being said,
But are you making any specific requests as it relates to this topic and this issue?
well, you denied the request that
Any other requests?
I just feel like it's smart for them to be tested. So it doesn't
what
come
if
up again in the
Darrell-
future, or potentially come up again in the future, because then we'll all be looking back and saying, well, we could have prevented something like this from happening if we had just nipped it in the bud from the get-go.
We are not ending this
It's
trial.
just smart
People
to,
have
like you say, err on the side of caution.
I appreciate that. I'm gonna continue. I understand what you're saying, but given this is a nursing you, I'm gonna base their desire to continue what I would interpret as their desire to continue. All right, then I want to talk briefly about the jury view. I did provide the parties with a proposed instruction. Before I get to that, though, Mr. Brooks, I have been thinking about your request yesterday. And I know I've had the overnight to really think about it. And if that is your decision to not be present for that, what I would say is this: I want you to be advised that you have a right to be at that jury view. Did you hear me say that?
Yeah, I mean, you pretty much told me yesterday about, everything that was going on. I just didn't listen to it being, well, I was still confused about why did there even need to be a jury view. That was my whole thing. I don't see the relevancy
Good
of
point,
it.
Marty.
And I also didn't agree with or consent to having to be part of something that I don't see as relevant.
I appreciate you making a record of that, but did you hear what I said, that you have a right to be present for it? I've ruled that let me back up. There's been a request from the state to have the jury look at the vehicle that was recovered was driven through the parade. Did you hear me advise you of that?
Yes, I heard.
All right, so that motion was addressed previously, and I granted the request for that jury view. Did you hear me say that?
I'm informed.
All right, thank you. So with that, you have a right to be present at that jury view. Did you hear me say that?
I'm informed.
And I would like you to be there. I believe it is a piece of evidence. That's why I've drafted jury instruction 152 the way that I did. Did you hear me say that?
I'm informed.
So my question to you then this morning is, do you want to be present at the jury view of the vehicle?
I don't see the reason why I would need to be present.
Well, that's my question to you, though, is do you want to be present for it?
Just
You
let him
are
stay in
the
his
accused
cell.
in this case. You're the person who the state has alleged committed these acts. The jury view will be to view a piece of evidence that frankly can't come into the courtroom due to its size, and the jury's going to be shown that. So do you want to be present at that?
For the record, I'm not a person. I'm a human being. And
Fudge.
no, I do not consent to or agree to being present at a jury view.
All right, then I'm going to honor his request, but what I am going to do, though, is as part of that process in any event, because it's being done in a secure location, is I have ordered that I want to make a record of what's being done, and I want a visual record of what is being done. And so this jury view is going to take place in the sally port of the jail, and precautions are being taken so that the jurors do not know where it's at. It'll look like a garage, right? Anything that says jail within the sally port is being covered up. That will be verified before anyone is taken in there. They will be transported to there. I'm not sure if they'll walk or drive because it's very close. But then the sheriff's department, because it's as the court official, I'm in charge of keeping the record, not keeping the record, I'm in charge of making the record. I want to make sure the record what is done for trial and certain purposes if need be. The sheriff's department is obviously charged with the security and safety of a courtroom, including the jurors. And so I have asked the sheriff that will be on a tripod that will record what's there before anyone gets there. I've instructed them to take that camera to walk around the vehicle and while it's recording to put it back on the tripod. And before the jurors and the court are brought in, once we are brought in, it will also be recorded, and that contemporaneous recording, so that will be as we will walk around the vehicle one time. That will be recorded, and then both of those recordings are going to be made part of the record. Because the second recording is for the record and has the jurors, at this point I'm going to seal it so that at least until the conclusion of the case, given the order that I have regarding the what's referenced as an anonymous or numbered jury, so that will be sealed. But what will be released to the public or be made part of the public record, and so therefore any media request, would be that recording that just shows the vehicle without the jurors in it and without the court. So, and then I plan on also bringing that back to the courtroom while the sheriff's department's going to bring it back, and then we'll show it to you at that time.
I have a question though.
Go ahead.
If I have a right to be present, then I have a right to not be present. How can this take place if I place without?
Oh, that's what he's trying to
It will
do.
take, I'm just going to honor your request not to be there.
I'm asking a question though. How can it take place without my consent or agreement?
Because it can.
If you don't, it's going to take place. That's how I'm going to answer that, sir. So you not going there is not going to prevent it from happening.
My Lord,
But you can forfeit your right or to be there by your conduct. And by your conduct, by not answering my question, by saying I don't want to be there and I don't consent to it, you will be forfeiting your right to be present and essentially waiving that.
Doesn't I have to sign something for it to be waived?
I don't think so in this case.
Well, yesterday you said something about
I know I said that, and I've had some time to think about that further, and I don't believe I need to take a full waiver with you signing anything or even agreeing to the waiver.
So why did I have to do that for when my
I'm not going to answer those questions because that would be for me to give you an explanation of the law.
No,
I'm just going to tell you that I'm not going to require a written waiver from you in order to honor your request to not be at the, or even if I phrase it, your lack of consent to the jury view.
And is that lawful law? Because
Sir, I'm not going to go through all the law that applies to that. This is my ruling. If you disagree with it and ultimately there is a conviction, you can raise that on appeal. But your lack of consent is not going to stop the jury view. It's going to happen. It's a piece of evidence that I cannot physically fit in this courtroom. It's too big. There's no way to get it in.
Okay, I'm informed of that, but at the same time, if I haven't signed any waiver, how could it be lawful? I haven't given consent or agreement to a jury view. I haven't waived any right.
You don't have to, dumbass.
When the whole issue was brought up on the record yesterday, my first thing that I said was, I don't see the relevancy of why there should even be a jury view.
It's not your
And that
fault.
was the whole issue. And yesterday I was told about the, I don't know how you say it, the colloquy or however you say it. I don't know how to pronounce it.
I know what I said, and I'm telling you I had time to reflect that was my initial
Well-
reaction to your statement yesterday, but I thought about it some more, and I'm changing a waiver with a colloquy with you and anything in writing. I'm advising you, you have the absolute right to be there. But I'm also advising you that if you choose not to be there, I will honor that request. And I'm not going to force you. I'm not going to direct the sheriff's department to, use any type of force, if you will, or require you or get you there without your consent. You either cooperate with that process or you don't.
The way I interpret the law, though, Your Honor, which the law is designed to be interpreted by the people. The way I interpret that is I have the right, or
He is on his 10th extension, Mountain Princess. His 10th. I don't know when they're going to say no more extensions and just be like, you don't get to appeal. I don't know why they don't just cut him off at some point.
essentially to be there or not to be there, and it still has to be an agreement or consent. That's how I interpret the law.
My ruling on that, sir, is I disagree with you. You do not need to provide consent for the jury view to happen. Your objection is noted for the record. I'll make a specific finding today that it is relevant to these proceedings, to this trial. There is an allegation that you drove through the Waukesha Christmas Parade on November 21 of 2021, driving a red Ford Escape, killing 6 and injuring dozens more. The relevance is that there is, in addition to the charges, there's an enhancer that has been charged as it relates to the intentional homicide charges and the first degree recklessly endangering safety, that you committed those acts while using a dangerous weapon. I would direct your attention to the meaning of.
We have decided it's the judge because Spike, I don't know what you want. Because we think another judge, well, some of us think another judge would have shut him down and have ended it. I kind of think it was good that he got her, because she was so patient with him. But other people think a more strict judge would have shut down his shenanigans. I don't know. No, he started spitting the cucumber out towards the end of eating. I don't have any cucumbers right now. I don't have tuna. Oh, I do have cheese. Maybe cheese will make him be quiet. I have no idea what he wants. It's driving me crazy. So that's what I think the consensus is. It was the judge, this particular judge. If maybe he'd gotten a stricter judge, that maybe they would have shut down the shenanigans earlier. Whereas he kept them up through the whole thing with her, even though that she was very gracious and patient and made a very good record for the appeal. But yeah, they've been over backwards to make sure his rights were protected.
A dangerous weapon, that the legal definition that was provided to the jurors in the preliminary jury instructions, and that the jury view is related to
the weapon
evidence that the state is presenting regarding the charges, and specifically the instrumentality that they allege is the dangerous weapon. So there's clear value. Again, your objection is noted for the record, but I will and am permitting the jury view of the vehicle. With that, I'm going to give I'm gonna move on to the jury instruction.
I don't agree or consent to that, Your Honor.
I understand your
If I'm not-
objection is well noted for the record. I need to keep going though. On the pattern and
I'm
jury.
informed that you need to
pattern-
keep going. I'm not trying to stop you from continuing to go. I'm merely stating for the record that there are things I do not understand how they're being permitted.
We know that, and you know who would know?
Versus
A
the
lawyer would
Constitution.
know.
I mean, I'm sure you're aware under Article 6, Chapter 2 about the Supremacy Clause that the Constitution is the supreme law of the land. So how can we disregard?
Mr. Brooks, I'm not disregarding the Constitution. Here's the thing, I've made my ruling, okay? Once I've made a ruling, I do expect that even if you disagree with it, you will not continue to argue it.
It's not
That
arguing.
we will continue on
I'm
with the
seeking
next
to
topic.
understand, Your Honor. It's not an argument.
Mr. Brooks, I'm not going to explain further other than what I have done, my ruling. My ruling stands. Now, I'm going to move on to the jury instruction. I gave the parties
May I
2
respectfully
documents.
reject that ruling and take exception to that ruling?
No.
Your objection is noted. I'm
For the
moving
record,
on
may I
to jury.
request a legal and factual basis for your
Mr.
ruling,
Brooks,
Your
please
Honor?
don't interrupt me.
No, that's
okay?
not how that works.
I give you an opportunity to raise your objections and to make your legal arguments.
raising
and then I make a
objection now.
ruling, and then you start in on something else. You need to give me your argument all at once. For you to interrupt me afterward is disruptive to me.
It's not
And
disruptive.
it's interrupting
It is.
and it's disruptive.
Good
It's
Lord,
definitely
man.
not disruptive.
Well, if that's my view of things, sir, and what I'm putting on the record is that it does disrupt what I'm doing and the flow of what I'm doing and needing to move on, having to interrupt what I'm doing so that I can address that once again. Please, please. I know you may not always agree with my rulings, but I'd ask that you show the courtesy and decorum that is expected of everyone. And once I make a ruling, we're going to move on. You don't need to keep objecting because your objection's already been noted for the record. I'm going to continue. We're going to look at jury instruction 152.
Well,
I gave the parties 2 documents yesterday. One was the pattern instruction, which I've modified, and then one is the draft of, and Mr. Brooks, please stop. You're continuing to talk over me.
Because
You're interrupting.
You said I have the right to object, and you didn't let me even get to the objection.
I did, sir.
No, you didn't. I was right in
Your
the middle of
objection
it.
comes before the ruling, not after. Once I make a ruling, we're moving on.
You made a ruling before we even finished the conversation, Your Honor. With all due respect,
Brooks,
before
please
we
stop.
even finished,
That's not true. Okay?
you
It's
said
not
I'm going to
true.
make a ruling. As soon as you even started in about
Mr. Brooks, I'm not
having
going
the
to
time to
spend
think.
hours on end making a ruling about a jury view on something I've already decided. All right? So please, I'm asking
Well,
you to stop. Stop
Nah,
interrupting me.
you can't
And please
just
listen.
disregard the United States Constitution. Which has a
I
supremacy
absolutely am
clause.
not disregarding the
You are.
United States Constitution
You're not
or the
honoring your oath
Constitution
of
of
office.
the state
Your
of
Honor,
Wisconsin.
are you not a public servant?
Okay, Mr. Brooks, you're starting to cross the line. You've already crossed it, but I want to keep going. I want
didn't
you in
cross
this
any line.
courtroom. But if you keep interrupting me and putting you on notice that you run the risk of being forfeiting your right to be present in this courtroom and continuing in the next courtroom so that I can effectively and without interruption continue with the proceedings this
So again,
morning.
you're holding me in contempt.
All right, jury instruction 152, as the state had an opportunity to review it.
Is that a judicial determination that I'm being held in contempt?
And I agree generally with the court's proposed instruction. I did submit kind of a counter-proposed instruction following much of the language that you had in your version, Your Honor. I just think it's maybe better to refer to this area as a garage instead of a sally port. I don't know that anybody knows what a sally port is unless they work in this industry. And instead of referring it as being in the
Or if they
Waukesha
work
County
someone's
Jail, I
property.
just suggested a garage attached to the Waukesha County Courthouse. I think that is factually accurate and would dispel any concerns about anybody being in custody or reference to a jail setting. I did email my proposed instruction to your clerk and I e-filed it, but I admittedly just did that a few minutes ago. So that's why I emailed it to the clerk, because it's probably not in your queue yet.
All right, why don't we print that off so that Mr. Brooks can review that as well?
Seems to be called that name. What do I need to be reviewing?
The state has submitted an alternate proposal for instruction 152.
And that's referring to this quote unquote jury view.
Yes. Thank you.
I accept for value in return for value this document. Now, I'd like the record to reflect, I still haven't received my original copies of my filings here this morning. With the
Pick
timestamp.
that up with the clerk of court. I've already told you that, stupid.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value the document.
Do you have any position on this state's proposal?
I'm still trying to understand the whole process.
He didn't read it.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're going to rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you
In
haven't.
any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor? Respectfully
sorry?
for the record, may I do that?
She needs to shut down that rudeness.
You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document. That was
Reference
was
to
accepted for value
the-
and returned for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to
Shut up and
Sallyport
listen.
of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse. Those would be in the first two paragraphs. I believe the rest is the same.
So it was a couple words changed.
That's my understanding.
So it's the same document.
No.
Let me know when you're finished reviewing it, and
I don't have to review the same document that was reviewed yesterday, accepted for value and returned for value yesterday.
All right, then let me ask you this, sir. Do you have a position on the proposed instruction from the state?
It's essentially the same document. What was the significance of the change?
Say yes
What-
or no.
What's the
jerk.
significance, garage, Sallyport? What is the relevancy of what it's called?
State want to put on the record again the basis for the changes you made.
Your Honor, to my way of thinking, it is beneficial to the defendant. It removes any reference to Sallyport, which some may recognize as being part of the Waukesha County Jail. It removes reference to the jail itself. And then in the second sentence, the pattern instruction was worded, and the court followed it. You will be taken to the Sallyport in the custody of the jury bailiffs. I just thought it was better to change that. You will be taken to the garage by the jury bailiffs. Again, removing the use of the word custody
Bye, Mal.
is it's factually true, but it's really irrelevant. Just to be cautious, Your Honor.
With that, sir, do you have any?
I don't
Position.
fundamentally understand that. I think everyone's well aware that I'm in custody. So how does the wording change what's already known?
It's your fault.
Everybody
I know
knows
you're
that I'm housed in the Waukesha County Jail. How does the wording change? What's already known. It's reported. It's reported on every single day, as it has been since the beginning of trial and even before that. So I don't think anyone's not privy to the knowledge of where I'm housed and that I'm in
just
custody.
not understand that they don't know that. He was a jury selection.
How does changing the wording change what's already known?
Thank you. From my perspective, of course, when I drafted this yesterday, factually, what I put in there would be accurate because that's where the jury view is going to take place. I think changing the verbiage so that it says a garage attached to the Waukesha County Courthouse takes away any possibility that other law enforcement is condoning what is happening or somehow related to the case. It is true the location was selected due to your custodial status and being able to secure the area for the court, for you, for the jurors, etc. But it's also a controlled environment, I think, a good thing for purposes of the jury view. And so I am going to adopt the draft that was submitted by the state. It still is factually accurate. And from my perspective, again, the importance of this instruction is to tell them what is and what is not evidence, and to instruct them and to not talk during this time. They can't discuss what they see during this time. This instruction will be read while we are still in the courtroom prior to the parties and the court going to the Sally Port for that viewing. And I've already discussed how it will be contemporaneously recorded so that it's part of the record as well.
So if I was there, where will I be at?
My understanding, if you choose to be there, is you will be escorted like you are in court here now. The bailiffs would be with you. You'd be in your suit.
No, where will I be at?
You would. I don't know exactly. That's up to the sheriff's department as to where all the parties are going to stand. Obviously, you would. We're not going to commingle you with the state or the state with jurors or you with the jurors or the court or anything like that. My understanding is we'll have sort of assigned places and that it's only myself who will walk around. And I may not even do that. I have to think about that. But the jurors are the ones who are going to walk around the vehicle one time.
So I don't get to walk around the vehicle?
I can have you do that before the jurors come in. I certainly can have you do that if you would like. I can give the parties that opportunity.
And may I add something else, Your Honor? I agree with everything the court said. I also think Mr. Brooks should understand that it will be a fair process. He's not going to be led into the room in shackles in front of the jury. It's my understanding from Captain Dussault, the attorneys for the state, the prosecution team will be in the room. Mr. Brooks will be in the room. We will be in our assigned location. It will be fair. It will match. There will be basically no distinction between how Mr. Brooks appears to the jury versus how we appear to the jury. We will be in there first. If the court's willing to allow him to walk around the car one time to look at it, we have no objection to that. And then the jurors will come in. No one will speak. They will do one lap around the car. They will leave the room, and then the parties will leave the room. That's my understanding, Your Honor.
And I will add to that, because it's been a while since I had some preliminary discussions with the Sheriff's Department on this, that if however many bailiffs, sheriff's deputies are with you, I want the same number with the state, right? And that's what we mean by it will look no different. So each party will be accompanied by deputies.
I have a question to that.
Okay.
How come none of that knowledge of how it would be conducted was discussed with me? I didn't know anything about
It's being
how the
discussed
bailiffs
with you
would
right
actually
now,
do
idiot.
things. how certain things would go. This is my first time hearing this.
Well, we have
So
preliminary time of the request back in August when you still were represented by counsel. And then I had some additional preliminary staff, which included Captain Dussault and someone from the jail to talk about it and the logistics of it. And then, of course, we're having the discussion now, which is, again, why there's no jury here now. I wanted to wait until the appropriate time and then make a record of everything.
But don't you
At no
think-
time did I have conversations independently with the state. They had filed a letter at one point because they themselves had, again, my understanding, and Attorney Opera can correct me if I'm wrong, had some discussions to see if it was feasible. They had some discussions with Captain Dussault. And Captain Dussault is with the Waukesha County Sheriff's Department. Of course, the Waukesha County Sheriff's Department and the sheriff is statutorily responsible for the security of the campus, security of the courtroom. And so that would be the proper person for any party to have discussions about a piece of evidence such as this. But I did not have any discussions with the state myself. That only happened in the setting of a courtroom or when a letter was received and I reviewed it.
Much shorter.
I haven't reviewed that letter or seen it. Don't you think that?
Specifically addressed with the jury status hearing, at which time he was represented by Attorney Perry and Attorney Keys. It is on file and it was addressed by this court, many of these details, Your Honor.
All right.
Many of the same
So-
details that's being discussed right now at this moment.
All right, Mr. Brooks, do you have a request as it relates to any of that?
Well, yeah, I'm still trying to understand the whole how this is all working, and then it was a reference to how the shackles would look, or how being shackled or not being shackled. I'm guessing that I can't just walk around freely with bailiffs. I'm sure there would be some type of shackles.
Just said there wouldn't be.
I
Jeez.
will tell them you are not to be shackled visibly for the jury to see.
And what do you mean by visibly,
And-
Your Honor?
God,
So-
bless America.
Obviously, when you sit in court, you're shackled to a table. They can't see that. I'm not going to have you in belly chains or in leg shackles. You're just going to be escorted. And it will be up to them how they determine.
Well, he may be in leg shackles, Your Honor, if there's a table or some way that they can keep that out of the view of the jury. Just like he is in court. He's shackled in court. He has been for 3 weeks.
Actually, these are
The security has to be left at the discretion of the Sheriff's Department.
these are leg shock devices, not
No,
shackles.
they are not.
Sir, the security is up to the Sheriff's Department. I should be careful not to overstep my bounds on that. And, you know, whatever is done, it should not be viewable or visible to the jury.
And why is that, Your Honor? I don't understand that part. Why is the jury not privileged to see
That is to your benefit.
shackles?
I'm not going to explain that any further.
I don't understand. I'm just seeking to understand. I don't know.
All right, I need to move on.
You're
So
an idiot. You've been told.
unless there's a
You'll never
specific
understand.
request, other than a statement that
Yeah.
you're making about your
Don't
lack of
understand that.
understanding,
You're never
I need to
gonna
move on with the other
There
topics
is
I
a
need to
specific
cover.
request. Why do I have to have ankle shocks on my ankles
They're not shocked, stupid.
to appear at this jury view thing?
I guess I'm not aware of what you're talking about. So were you advised by the Sheriff's Department that that would be the case?
Well, the DA just said that I would have the ankle shocks on.
No, shackles, she said.
No, these are not shackles. They're shock
No,
device.
Judge, I think perhaps we can move on. I think maybe because this is going to have to occur on a break, the bailiffs can take him down there if Captain Dussault is willing, show him what it's going to be like, show him how he's going to get there, and he can decide at that point if he wants to be there or not when the jury comes in the room. We're spending a lot of time talking about security and things that are frankly beyond your knowledge and my knowledge.
I object to that. I'm simply trying to understand, why do I need ankle shocks.
I'm going to leave the security. I'm not going to make any specific orders. I'm going to backtrack a little bit. I will leave the security of the jury view to the Waukesha County Sheriff's Department. That is their responsibility. And I trust that they will do what needs to be done to maintain the security, no different than what they do here. And in their discretion will determine how best that takes place. And if I need to address anything after that or at that point in time, then it should be brought to my attention, but we are going to move on this morning.
So I should discuss that with the sheriff?
Yes. So I know, Mr. Brooks, you filed with the court 2 documents. I'm going to take them under advisement.
No, it's
I'm not
one
going
document. It's one. It was 2 papers, but it's one document.
Oh, all right. Thank you for that clarification. It's 1 filing, 2 papers, just front side, entitled Alleged Defendant Jurisdictional Challenge and Mandatory Judicial Notice by Affidavit. It references the case caption, the case number. I will simply take it under advisement and I'll review it later. And if I believe it needs to further be addressed, I will do that. But it's my understanding, sir, that you are requesting the original back. Is that true?
Yes.
So normally, just so you know, when documents are filed with the court, we maintain the original until it's scanned in and it's audited. And then because it, under the statute, once it's e-filed or into the electronic filing system and the electronic case, I believe we just destroy the documents at that point. So I don't have an issue giving you back the original, but it needs to run the normal course. My clerk needs to scan it in. I've advised you of this previously, but in the courtroom, we don't have the time stamp. We just have the date stamp. I will state for the record that you provided this. It was right away at the beginning of the morning, so at 8:30 a.m. is when it was filed with the court, so that will be on the record. And then at some point today, when we're on a break, my clerk can scan it in and then provide the original back to you, and then I'll have the electronic copy to review and address as I deem appropriate. Here you go, Madam Clerk.
I want to say to that too, in reference to that, I actually said on record numerous times that I wanted the original copies of all my filings. I've actually said that 3 times on the record. This would be the 4th time. Every filing that
I'm going to give it back to you, sir, but I'm not required to by law.
Well, I'm just saying on record that I've asked for that numerous times.
Your statement's noted for the record. All right.
So would I be able to get all the original copies of all my filings?
I'm not going to address that any further, sir, because I am not the official keeper of the record. As to what was filed this morning, as a courtesy, we will provide you back with the original once it's scanned and it's in my electronic file.
I was told that you make the decision if I can get the original copy.
And I just made a determination you could have the original back of this.
Can I have the originals for all my filings?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I have the copies. I don't have the originals.
All right, I'm going to move on.
I have
sir.
them here.
This is taking up valuable time with the jury. We need to keep going.
Is that a judicial determination, Your Honor, that I can't get an answer to
I
something?
don't believe there's any other preliminary issues we need to address unless the parties have anything from the state.
Just very briefly, Your Honor, to advise the court, I have 4 witnesses here that I believe are very, very brief records custodian type witnesses on some video evidence. I'm hoping my direct should take 5 to 10 minutes for each of them. And then I have 2 police officers who will be testifying. There will be some physical evidence involved when those officers testify. And Detective Casey went to retrieve it and he will bring it to the courtroom. When that moment comes, do you want me to have Detective Reglan take the exhibits to the witness stand, or what is the court's direction on that?
I would like you to provide it to the Sheriff's Department bailiff who's in the courtroom, my bailiff, who will then take it to the witness stand.
Okay, Deputy Bordeaux and... Yes, okay, I understand. Thank you.
All right, thank you for the roadmap for today, if you will. Anything preliminary other than the filing, sir, and other than the topics we've discussed this morning?
Yeah, I'm still wondering when I will get the copies back for the ICFs that I filed.
I can't answer that. I don't have those, sir. You'll have to reach out to Clerk of Court Monica Paz.
Well, what happened to them?
I don't know. They're not part of the record. So you'll
They
have to
should
take
be.
that up with her by an inmate communication form and ask her for those, but I'm not going to address that any further on the record. All right,
should
let's bring
be.
the jury up.
It's kind of funny that they disappeared. No,
As
ICF
soon as
disappeared
fact,
before.
Not an evidence, sir, so.
They haven't disappeared before. I've always got copies. What's the difference now?
He doesn't know,
All right, for the jury.
jackass.
We need to make a record though.
So I have to readdress her the same thing in order to get copies that I've always been getting since the beginning of you telling me to file ICF.
Sir, as a courtesy, if you have not been provided copies with, I will as a courtesy instruct my clerk, Teresa. They're not going to be dates or timestamps other than what's in the file. They'll be from the electronic file, but you need to provide her with a list, and then I will do that as a courtesy to you. But I'm not required to do that. But as a courtesy, I will do that. And as far as any ICFs, if they weren't directed to me, then you will have to follow up with Clerk of Court Monica Paz. I don't have them. They're not part of the file.
Then why were you getting them before?
You'll have to ask her that.
I have to ask her why you were getting them before?
My understanding is they were forwarded to me, sir, but we'll,
So what happened to this one being forwarded to you?
sir, I can't answer that. I can't answer what I don't know. So
It
the
seems
jury's
like you're
coming
trying to
in. We're
avoid
going to
it. That's
we're
what
going
it
to
seems
continue
like.
with the trial. So thank
Just
you.
like you've avoided subject matter jurisdiction. You haven't proven that on the record.
Thank you, everyone. Please be seated. And thank you for your patience this morning as the court addressed some legal issues with the parties. All right. If the state would, please call their next witness.
Thank you, Judge. The state calls Steve Schloman.
Good morning, Mr. Schulman. If you would please make your way to the witness stand, which is up one riser to my right. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. Just give me 1 second. All right, go ahead. If you would please state your first and last names for the record and then spell each.
Stephen Schloman, Steven Schlomann.
Thank you. Go ahead, your witness.
Thank you. Good morning, Mr. Schloman.
Morning.
Sir, what is your job title?
I'm the IT director at Waukesha School District.
And are you aware as to whether or not the school district maintains security cameras at the buildings on the school district property?
Yes, we do.
Overruled. It's foundational. The witness may answer.
I'm sorry.
Yes, we do.
Okay. And specifically, is there school district property located at the address of 222 Maple Street or Avenue in the city of Waukesha?
Yes.
What?
Overruled. It's foundational. The state or the witness may answer. I believe you did, and your answer will stand. If there is an objection, sir, wait until I rule on it before you answer it. Thank you. Go ahead.
What building is that location, sir?
That is our district office.
Hey, Terry.
And is there more than one security camera on that building?
Overruled, the witness may answer.
Yes.
How many are there, sir?
Overruled, the witness may answer.
I'm not exactly sure, but I believe there's about 8.
Okay. Directing your attention to the days following November 21 of 2021, were you contacted by the Waukesha Police Department for any reason?
Yes, I was.
For what reason?
They asked me to look at my external security camera footage to see if I saw anything unusual on it.
And that would be specific to the building at 222 Maple Avenue?
That's correct.
Overruled, the answer may stand.
I'm going to show you an item that's been marked as, well, let me ask you one other foundational question. Do your security cameras record the activity?
Yes, they are recorded on a digital video recording system.
And can be viewed later?
That's correct.
Okay. So when the police came to you in the days following November 21 of 21, did they ask you to check a certain day and time on the video recording for the building at 222 Maple?
Objection.
Overruled, the witness may answer.
Yes, they asked me to look at Sunday. Well, this was Monday. When they contacted me, and they asked me to look at Sunday at approximately 4:30 p.m. in that range.
Okay. And did you do that, sir?
Yes, I did.
And did you view any video that you thought may be helpful to the police?
Yes.
Did you turn those recordings over to the police?
Yes, I did.
Had you changed or altered the content of the recording in any way?
Objection, leading.
Overruled, the witness may answer.
No, I have not edited it or changed it in any way.
Okay. Now I'm going to show you first an item that's been marked as Exhibit 157. And for the record, Your Honor, I'm just laying the foundation with these videos with this witness. I do not intend to display them at this time.
Will there be more than one?
With this witness has 2.
And that will be Exhibit 157 and...
158.
All right, thank you. Go ahead.
So is there an image on the screen in front of you, sir?
Yes.
Okay. Do you recognize what we're seeing there, sir?
Yes.
Could you please tell us what is shown on the front screen of Exhibit 157?
Objection, leading.
Overruled, the witness may answer.
This is the side of our Lindholm Administration Building at 222 Maple.
Okay. Do you need to see the like 5 or 10 seconds played, or are you confident that's what we're looking at here?
I'm confident that's what we're looking at.
All right. Do you believe the video contained in Exhibit 157 will be a true and accurate depiction of the events from this location on November 21 of 21?
Objection, speculative.
Do you want him to see the video first? Why don't you show him the video first?
Well, the video is 20 minutes long, Your Honor.
Oh, all right.
Or I'm sorry, 11 minutes long. But I think he's made the adequate foundation, Your Honor, that he's confident where this camera is and what it shows.
All right, with that, the objection's overruled, and I'll receive Exhibit 157.
Thank you. Now I'm going to display for the witness only Exhibit 158. Do you recognize what is shown in Exhibit 158?
Yes.
Please describe it.
Objection, leading.
Overruled, the witness may answer.
This is our rear parking lot at the Lindholm Administration Building.
At that same address?
222 Maple, yes, that's
Okay.
correct.
Is this a second camera?
Objection, leading.
Correct.
Overruled, the witness may answer.
Correct, this is a second camera.
And does this appear to be one of the video clips that you also provided to the Waukesha Police upon their request?
Yes.
And for the record, again, Your Honor, this entire video is 11 minutes in duration. Based on the testimony of the witness, I do not intend to play any of it at this time, but I would move to admit 158.
Objection. It's not intended to play. What's the relevancy?
The objection is noted. It's overruled, and Exhibit 158 is received.
Thank you. I don't have any other questions.
All All right, thank you. Go ahead, sir. Do you have any questions for this witness?
Brief. Before today, sir, well, first of all, good morning.
Good morning.
Before today, had you seen these exhibits or videos, rather, 157 and 158?
I've seen this video when I collected it off our system.
And do you recall seeing the first one?
Yes, I do.
Do you recall when you saw those videos?
I saw those Monday morning when my detectives came and asked me to review video footage.
And do you recall the name of the detective that you reviewed the footage with?
I do not recall the name of the detective, no.
And after that, after initially viewing these videos, did you follow up with law enforcement after that?
Yes, I did.
And it would be fair to assume that that was strictly about the videos.
Correct.
And had you obtained any knowledge outside of what was shown in the videos?
I'm not sure I understand the question.
Had you obtained any knowledge to why you were asked to provide those videos at that time?
No. I was just asked to look at my videos and see if I saw anything unusual, any unusual activity in the parking lot.
And do you recall being informed that it was a possibility that you would be testifying in this matter?
No, I did not know that.
Were you subpoenaed at any time?
Yes, I was.
And do you recall about how long ago you received that subpoena?
Several weeks ago.
So pretty recent, would be fair to say.
Yes, I would. Well, several weeks ago. I'm not sure if that's your definition of recent or not, but
Do you recall who served you the subpoena?
Objection relevant.
Grounds.
Overruled. The witness may answer.
the district attorney's office from Waukesha.
Do you recall if it was a specific district attorney?
I do not recall.
Do you recall if you were contacted by the plaintiff in this matter?
Objection.
Grounds.
Vague.
Sustain as to the form of the question.
Do you recall having a conversation with the plaintiff?
Objection.
Grounds.
Misleading, legally inaccurate statement.
Grounds.
Sustained as to the form of the question.
Do you recall having a phone conversation with the plaintiff in his
Same objection.
grounds?
Sustained as to the form of the question.
Do you yourself recall Do you yourself recall reaching out to the plaintiff in this matter?
I'm not sure who the plaintiff is. Can you define that for me?
The plaintiff would be who's bringing the claim.
Your Honor, I object. Well, I realize there's no question at this point, but if he's going to ask the witness to answer his prior question, now that he's clarified this is irrelevant questioning.
We'll see what his question is first.
I asked it.
Please ask your question again so that I'm clear.
Have you yourself ever reached out to the plaintiff in this matter?
And my objection is it's vague and it's legally inaccurate.
Sustained as to the form of the question.
Do you even know if there's a plaintiff in this matter?
Objection,
Grounds.
argumentative.
Sustained as to the form of the question.
Hurry up, Darrell. We got another crowd to get to.
Have you yourself filed any complaint in this matter?
Objection,
Grounds.
irrelevant.
Overruled, the witness may answer, sorry.
I have not, no.
Do you know of anyone who filed a claim in this matter?
Objection,
Grounds.
irrelevant.
Overruled, the witness may answer.
I do not.
And do you recall when you submitted the videos to law enforcement?
I submitted them on Monday afternoon.
And do you recall what method you submitted it in?
The detectives came to my office and they viewed the video on my system directly, and then they asked me to put it on a flash drive, so I downloaded it on a flash drive, exported it to a flash drive, and then they took it.
No further questions?
Any redirect?
No, Your Honor, I'd ask Mr. Schloman be excused.
All right, thank you, sir. You may step down. And he is excused.
Okay. The Tootsie Roll in my mouth. Now we're going to go over to our new trial. This should redirect you. It is the Amber Alert murder trial, New Hampshire v. Dustin Duran. The kids are fine. Don't worry about the kids. He shot his baby mama because she was going to kidnap the kids. And after he shot her, then he took off with kids. That's why it's an Amber Alert. Yeah. We went to Walmart yesterday and we got separated and I ended up in the Halloween aisle. It was a bad choice. Okay, let's see if this works. I'll see you guys in a few minutes.